We have been working off the record with the instructions so that we can have a succinct charging conference. And I'm going to go through the instructions that we have gone line by line to make sure that the record is clear where there is agreement and where there are objections. So for the record, I have all defense counsel present. Mr. Fernandez Saldana is present. All assistant state attorneys are present. And this court is referring now to the title page. Any objection to that?
No, Your Honor.
None from the defense.
And I'm going to go through introduction to final instructions and statement of charges. Any objection to either one of those instructions?
No, Your Honor.
No, Your Honor.
First degree murder. Any objection to this instruction?
No, Your Honor.
Lesser included crimes. Here, the defense was willing to waive the lesser included. Is that correct?
That is correct. And we did have consultation with Mr. Fernandez and explained to him our position. He was in agreement, but we understand at the request of the state that they're included.
All right. Did the state want the lessers?
Yes, Your Honor.
All right. I'll give the two necessary included lessers requested by the state, which are second degree murder and manslaughter. Moving to second degree murder. Any objection to this instruction?
No, Your Honor.
No, Your Honor.
And for the record, we did discuss the alternate language related to the word imminently dangerous act. And so we've all decided that that other language doesn't apply to this case. Are we all in agreement with that?
Yes, Your Honor.
Okay. Manslaughter, we discussed this instruction and agreed on the procurement instruction, agreeing that manslaughter by act does not apply in this case.
Agreed.
Agreed.
Okay, so we've taken out that reference, and so we agreed with this instruction.
Agreed.
Yes, Your Honor.
All right. Count 2, criminal solicitation. Any objection to this instruction?
No, Your Honor.
All right, so we spent a significant amount of time on principles. Mr. Hill, so the first half of this instruction, which is all the standard, you did agree with that, is that correct?
That is correct, Your Honor.
Now, when we get to the second portion, did you have an objection to this one?
The only objection I had was deviating from what is listed as a standard instruction in the current rule book by including manslaughter.
All right. So what you're referencing, this court put a sentence at the request of the state. The following instructions applied to count 1 of the indictment, and the second paragraph, which refers to the lesser included crimes of second degree murder. Over the defense objection, I'll overrule it. I will include the crime of manslaughter. This court finds that it is a correct statement of the law. It is a lesser included offense of the charged crime. The standard for giving an instruction is there some evidence and is a correct statement of the law? It is not, admittedly, in the list of crimes that were bracketed out. However, the court will cite that in a normal homicide, and I say quote unquote normal, that language would be given along with second degree murder, that there is no need for the state to prove that the defendant intended to cause death. So this court finds that even though it's manslaughter by procurement, the state, Mr. Mizrahi, you argued that it's the procurement of the act, not the result.
Correct.
All right. So I will overrule the defense objection and give the instruction as written. Date of crimes, venue.
No objection.
No objection.
I'm going to roll through a couple of them, okay, because I don't think plea of not guilty, reasonable doubt.
No objection.
weighing the evidence. We agreed on these, correct?
We did.
Correct.
Right, so both pages of that. Defendant not testifying will be given. The only change was that in the second paragraph, I took out did and just put did not by agreement with the defense. Is that correct?
Correct.
All right, rules for deliberation, notes, cautionary instruction, verdict. Any objection to those instructions?
No, Your Honor.
No, Your Honor.
Now, Mr. Hill, the verdict forms, make your big debut with your
Yes,
request.
Your Honor. We consistently always request to move defendant, we the jury find the defendant not guilty to the top of the list.
Okay. All right, so I did comply with the defense request to move not guilty to the first page, even though it leaves the signature line on the second page. However, I will deny the defense request to put not guilty first. The court finds that while the defendant is presumed innocent of the charges, to do that would then conflict with the verdict instruction, which has the jury find the defendant guilty of the highest crime and then work down from there if they are not satisfied with the evidence. So for those reasons, the court will deny the request. Second verdict form, any objection to that?
No, Your Honor.
No, Your Honor.
Now I'm going to roll through a couple of them, single defendant, multiple counts, and submitting the case to jury. Any objection to those instructions?
No, Your Honor.
No, Your Honor.
All right, that will conclude the charge conference. I will finalize the instructions with a couple formatting things that I saw. I'm going to stop my share. Counsel can have leave to set the courtroom up for closing argument. I'm not sure where did Mr. Holman go?
He's right in the hallway.
Okay. Let me know when you're ready for closing. I just want